Hi there, and welcome back inside the Civil Litigation Department within MLFA's Legal Division of the CLCMA. I'm Christina Jump, and I am the Civil Litigation Department head, so I lead our team that handles all of our civil litigation, lawsuits, and administrative cases. We've been busy lately. We have filed in the past 6 weeks 2 separate petitions to the United States Supreme Court. And I want to talk to you a little bit about each one of those. Now, a quick overview. Filing a petition with the Supreme Court does not mean that the Supreme Court will necessarily agree to make a decision on it. They may not decide to take it up. They may say, no, thank you, and deny the cert, which is what it's called, because it's a petition for a writ of certiorari, which is a mouthful. So we usually just refer to it as a petition with the Supreme Court. So the Supreme Court may choose to deny our petition. And in fact, on average, the Supreme Court tends each year to deny between 97 and 99% of the petitions that are filed with it. So it takes 1 to 3% of the cases. We have been filing petitions with the Supreme Court since 2018. Not too long after I started working here, which was early 2016. And so far, we've done about 2 a year. We have not had an opportunity yet to have the Supreme Court accept one of our petitions and decide that it is going to hear oral argument on one of our cases and then make a decision. We're going to keep trying, and we hope that that does happen. Even if it doesn't, though, we are proud to file these petitions, and we are proud to get them in front of the Supreme Court and in front of other attorneys and in front of the government and the government attorneys, so that the agencies see that if they want to fight us when we represent a client and when we take on litigation on behalf of a client, it's going to be a long haul. So we hope they will be granted. We don't have any guarantee at this point because the Supreme Court is in recess. We have to wait, not very good at that, but we have to wait until October, when the Supreme Court comes back into session. And at that point, shortly after that point, hopefully, we will know whether the Supreme Court will accept and take on either one of the petitions we filed on behalf of our clients. The first Supreme Court petition that we filed in the last 6 weeks. We filed at the end of May of this year. And that petition is on behalf of Lassana Magassa. Now, we've reported on him before, and we have a lot of different lawsuits actually on behalf of Dr. Magassa. He's now gotten his PhD, so he is in fact a doctor. During the time that we've been representing him, he completed his PhD and dissertation. So we are proud to represent Dr. Magassa. We've reported on him before, and there are a lot of different issues, and as I mentioned, there are several different lawsuits that we have for him. The issue in the petition is pretty clear and simple. And we filed this petition, which I want to show you so that you can see what they look like. They have to go to a printer, and they look like this, in a specific booklet, specific size, shape, binding. It has to be very particular, and the Supreme Court makes sure won't accept it if it doesn't look like this. This is white, not because we like the boring color, but because all of the petitions that are filed are white. And then a response that's filed would be a different color, and a reply to a response would be in bright orange. We've done some bright orange before. We got some of that on our shelves, but the petitions come in white. So the issue that is in our petition that we briefed to the Supreme Court and that we filed in late May is pretty straightforward. There is a statute that says that if an agency makes an agency decision after hearing agency testimony, hearing testimony from the complainant, and looking at evidence and makes a ruling, basically through an administrative level trial, then that should go directly to an appellate court in the federal courts if the plaintiff doesn't like the outcome. It should not go to a trial court. It's fine. That's a statute. It has a good reason to not duplicate efforts. But what the courts have done here is they don't give us anything. We don't get the merits. We don't get to the answer. We don't get to the substance, and we don't get a chance to have all of that information set forth. At the administrative stage, it's a really thin file of not many pages for the part that we are bringing our petition on. And because of that, we are saying that's not what this was created for. And this is not a decision. The set of rules doesn't count as a decision. And by definition, a set of rules that governs how an agency resolves or looks at or considers or responds to any complaint that it receives, that set of rules is not the decision. It's different from the decision. It's the outline that governs what might lead to a decision and what is intended to lead to a decision on the substance, but it's not the decision. Except in Dr. Magassa's case, unfortunately, the Ninth Circuit ruled that it's case law, and it recognized flat out that this makes no sense. It recognized that its case law says set of rules is a decision by an agency, and therefore it's got to go straight past the trial court, and you got to go to an appellate court, which will only review what's in the record, even though there's not much in the record, because they told you they weren't going to tell you anything, because they told you they didn't think they had to. There wasn't really a whole bunch of information exchanged like this statute was meant to cover. And so there's not an actual decision. There's not substance of the decision. But there's a set of rules, and technically that counts as a decision, and we agree that it's wonky, but we're bound. So there we go. You can't go to a trial court, and Dr. Magassa does not get his day in court. We disagree. We want Dr. Magassa to get his day in court, so we filed this. We filed the petition on behalf of Dr. Magassa, and we are waiting on all of these defendant agencies to respond. And then hopefully the Supreme Court will respond and tell us whether it is going to hear that discussion. The other case that we filed a petition on with the Supreme Court within the past 6 weeks is even more recent. This is the second case that we filed a petition on to the Supreme Court in the past 6 weeks. And this one, we filed the petition with the Supreme Court on July 10th. So much more recently than the first one that I talked about, which was the end of May. In this one, we represent Haseeb Abdullah, who is an attorney who has worked for the state of Texas and currently works for Travis County within the state of Texas, which covers Austin and some other cities surrounding Austin. And because of his employment with a state agency, with a state entity directly for the state, or with a public entity where he works for the county, for Travis County, Mr. Abdullah has contributed to a retirement fund. He has to, under Texas law, and he has made contributions, and he is vested in his retirement benefits earmarked for his name from both his employment with the state of Texas and his employment subsequent to that with Travis County. Now, after that, and he's still paying, incidentally, he's still working for Travis County, still working for the county, and so he is still paying into this retirement fund. And he, like I said, he's vested in both, so it's his money. He has a right, a claim to that money, which is important for the courts. So if we look at that, what we said is that the state of Texas has to put the financial interests of its employees' funds at the forefront. That's going to be the top consideration of how it invests that money, which is already earmarked for at the bare minimum, or like Mr. Abdullah, actually they are vested in those funds for their retirement. They have to follow their fiduciary duty, or their duty to do the best job they can financially, to be good custodians of those funds, to take care of those funds on behalf of the public employees like Mr. Abdullah. Except Texas decided to put something else first. The state of Texas passed a statute that says if any company, if any entity supports BDS or boycotting Israel, now BDS stands for boycott, divest, sanction. If any entity supports boycotting Israel, any individual in Israel, not just the policies of the government, any individual in Israel, any company located in Israel, anything that the state of Texas itself, by way of a decision made by the comptroller of the state of Texas with a list that that comptroller alone creates. If Texas decides that any company supports boycotting Israel, or an Israeli citizen, or a company located in Israel, or a company that does business with Israel, or just something that the state of Texas disagrees with that has a connection to Israel, it's really that broad as how it's worded. If any company fits any of that definition, as far as one individual within the state of Texas is concerned, and that one individual then puts that company on its bad list, on its naughty list, then these retirement funds, the people who govern these retirement funds, cannot invest in those companies, no matter how big they are, no matter how financially sound they are, no matter how good of a financial decision and a financial return that would be, and no matter how much that would help the money of these public employees like Mr. Abdullah grow and become more and help for their benefit for their retirements. The state of Texas says if that one person puts any company on this one list, then those fiduciaries, the people in charge of that money in the retirement systems, cannot continue to invest in those companies or start investing in them in the future. So the top priority has to be the political preferences, which are openly based on religion. If you look at the language from when this statute was presented and passed, they have to put, the state of Texas has to put, and those fiduciaries are required by law in the state of Texas to put the politics and religious preferences of one individual within the state of Texas government before, in front of, as more important than whatever the financial return might be, whether something would be a good investment. Now, the state of Texas says this is okay. It's totally fine to do that, because what we're doing is preventing religious discrimination. Except that's not what the statute says. What the statute says is that if the entity boycotts any individual in Israel, any company located in Israel, not just the policies, not just Judaism, not the Jewish people in general, but any one person, any one company, anything, any one policy, any rule, anything with what Texas considers to be a connection of some kind to Israel, then that's more important to the state of Texas than the financial well-being of the retirement funds that its public employees have worked really hard to create. And for that reason, we filed this petition, which is on behalf of Haseeb Abdullah. And we filed this, as I said, on July 12th. And we are suing, now it's interesting, we originally sued the Attorney General, Ken Paxton, who was the Attorney General and performing those official duties for the state of Texas at the time that we began this lawsuit. But by the time we filed this petition to the Supreme Court, Ken Paxton is not performing those duties at the moment because he's been impeached, and under the laws of the state of Texas, unlike within the federal government, if a public official has been impeached by the state, and he was by a vote of the Republican legislature, then that employee, that person holding public office, can't continue to do the duties until that impeachment proceedings resolve. So we actually no longer can sue Ken Paxton because he's not permitted to perform the duties of the Attorney General in the state of Texas right now. It'll turn on the outcome of his impeachment trial, which is set for a few months from now. So we brought the suit against John Scott, who was the interim Attorney General, on the day that we filed this. No joke, 2 hours later, John Scott resigned and somebody else is now the Attorney General, or performing the duties of the Attorney General for the state of Texas. So it's changed names a few times. We also list the comptroller there. and a few other, mostly it's the comptroller and the attorney general. Those are the two people in public office that we point to because the statute points them, because the statute gives them authority. And one other thing that this statute in Texas does, other than say you can't boycott Israel or Israelis or Jewish people or anything, well, actually it doesn't say Jewish people. You can't boycott Israel or Israeli policies or anybody living in Israel or anybody working in Israel or anybody having anything to do with Israel. You can't do that. And that's more important than the financial well-being of these retirement funds, which are not doing awesome. In addition to that, the statute that Texas passed and that we challenged on behalf of Mr. Abdullah also says both the attorney general and the comptroller, the two defendants in our lawsuit, don't have to worry, and neither do those fiduciaries of those retirement funds. They don't have to worry about breaking the law, because you know what? We're also in this same statute going to just throw in their blanket protection. If anybody says that you violated any other duty that you had, any other law that you have whatsoever, by way of following and adhering to this list that we create, that this one person in Texas creates based on really vague standards, if anybody says you're not doing your duties, you're not upholding your job, you've broken some other law, don't worry about it. It's okay. We got you. Because we're going to give you just complete immunity for anything and everything that you do that comes out of following the language of this statute, punishing those companies that we, as a state of Texas, as decided and communicated by one person, decide is something that we think is being mean to Israel or to people in Israel. And we don't say that it's based on religion. Now, as I said earlier, when the law was proposed in the Texas state legislature, religion absolutely came up. In fact, Representative King, who proposed it, said, because of my Christian faith. Because of my Christian faith, says the lawmaker in Texas. And the history of Jerusalem, the history of Judaism, I'm paraphrasing that exactly, but really, really close to that. It is quoted in our petition. Because of my Christian faith and the history of Judaism, that religious connection is why I'm proposing this bill. And that religious connection is why I think this anti-boycott statute is super important, more important than the health of the funds that these public employees in Texas have worked hard to create and are hoping will be able to sustain them throughout their own retirement. So we filed our petition on behalf of Haseeb Abdullah, and it is suing whoever the attorney general, acting attorney general happens to be at the time that we hope that we get to the Supreme Court, as well as the comptroller for the state. And that is Glenn Hagar. And he's not impeached. He's still doing this as far as we know, or at least at the time of making this video. So that name has not changed and has remained the same. We don't think that's right. We think that the fiduciaries of these funds in Texas should not have to be told that they must put Texas's political and religious preferences above their real job duties. We hope that the Supreme Court will accept our case and will grant the petition, or the petition for a writ of certiorari, to say it the long way. And we will let you know either way. We will continue following this. And regardless of what happens, we are very proud to represent both Dr. Magassa and Haseeb Abdullah in filing these petitions, bringing the issue to the attention of the Supreme Court, whether they grant these petitions or not, and continuing to do the good work that we do here within the legal division, and that is made possible by all of the donors who contribute funds to the Muslim Legal Fund of America, because you all make it possible for us to do the jobs that we love. Thank you so much. We'll keep you up to date, and let's keep our fingers crossed for at least one of these for the Supreme Court come October.